Good morning, good afternoon, good night, and welcome to Beacon Hills um, CLE, Civil Litigation, eDiscovery, and me. I'm your host, Leandria Coates, and we're just going to jump right in, okay? All right, so today's agenda is we have the welcome, the panel introduction, the CLE presentation, questions and comments, final tips and takeaways, all right, so I just wanted to say welcome to everybody who's watching, everybody who's joining from wherever you're joining from. We worked really hard on this presentation, so we hope that you enjoy it. So I do have some housekeeping matters that I did want to go over with you guys. I bought cue cards because I want to make sure we have everything. I know and I hope that I'm talking to a group of attorneys and anybody else who cares to join. All right, so one, make sure you have pen and paper. No question is a silly question. We hope that you enjoy this. All right, so there will be a CLE sign in, a CLE sign out. And I do want to say this and give you some specific instruction for New York City attorneys that are watching and seeking CLE credit. If you are a New York City attorney who is seeking CLE credit, you guys were approved, or this course was approved under the New York City approved jurisdiction. And because of that, there are certain things that you must do to meet the criteria for the CLE credit. So I want to just kind of tell you that you have to have some type of documentation, and there is something that like you have to confirm in another way besides signing in and signing out that you are actually in attendance for this CLE. So because of that, I have come up with a word. So the word is neighborhood. Throughout the presentation of this CLE, I'll say neighborhood at least a certain amount of times. All right. So in order to actually get credit, you'll have to know how many times the word neighborhood was said. Okay. All right. Um, you will have to, in order to sign in and sign out to the CLE, you must email me your name, bar number, and city or state in which you are seeking CLE credit. I hope that that makes sense for everybody. I'm going to tell you when to sign in and sign out, so don't worry about that. I just wanted to kind of give you a cursory understanding of those things so that you understand. Get it, got it, good. All right, so next up is, with all of that being said, welcome, welcome, welcome. I think that's all the housekeeping matters that I have for you. Let me make sure. Let me check my notes. That is all the housekeeping matters. And so without further ado, we're going to introduce our panel. Well, no, we're not going to introduce our panel just yet. I'm going to have you sign into the CLE. All right. So if you are attending this and you want CLE credit, email me. Let's see. Email me here with your name, your bar number, and the state you're seeking CLE credit. And that's your sign in. Okay. So if that's something that you are seeking, if that's something you want to do, if you want to get credit for the CLE, you must do this. I need that timestamp. We need paper trails here. Okay. All right. So while you're doing that, while you're getting those emails sent over to me, we will start introducing our panel. So up first, today's panel. All right. I'm going to bring Andrea up to the stage. Hi, Andrea. How are you doing today?
Hi, I'm good. My name's Andrea Wasser. I'm a litigation paralegal at Robinson Bradshaw.
All right. So tell me a little bit about yourself. Tell me your favorite food.
Oh. Mac and cheese by far. Definitely is my favorite food. But a little bit about myself. I've been a paralegal for about 6 years. And we'll talk a little bit more about my experience later on in the presentation. And have had some pretty hands-on experience with eDiscovery within the civil litigation process. So excited to be here.
Yay. Okay. So I'm gonna click over to the next person, but I'll be back to you, okay? All right, Jigna, how are you?
I'm well, thank you. My name is Jigna Dalal. I am a eDiscovery director at Beverage and Diamond.
Hi, Jigna. So what's your favorite thing to do on the weekends?
Oh, read a book.
All right. What's the last book you read?
Well, I'm currently reading Demon Copperhead. So it's a tough book to read.
Okay. All right. Can you tell me what it's about briefly? Because it sounds very interesting.
Oh yes, it's a follow up, or it's inspired by Charles Dickens' David Copperfield, so Demon Copperhead, and it's about growing up in Appalachian country area and dealing with poverty, drugs, lack of education, coal mining, etc.
Oh wow, that's amazing. I admire anyone who reads. All right. Thank you so much, Jigna. We're gonna head over to Rashad. You're next. Hi, Rashad. How are you doing today?
I'm doing very well. How are you?
I'm doing well. All right. Tell me a little bit about yourself.
Rashad Hamilton, born and raised in North Carolina, proud North Carolinian. Went to NC State undergrad in Carolina, UNC Chapel Hill School of Law, and have been practicing in Charlotte, North Carolina for 3 years.
What's the hardest thing that you've learned since you've been practicing law?
Oh, I think it's discretion, and it's a ever evolving process. It's one thing to know the law. It's another thing to consider the best decision, considering not just the law, but cost and the client's interests and the interests of all external parties. I mean, it's been probably the more difficult aspect of practicing law, something I certainly underestimated.
I'll say this. This probably isn't funny, but it's funny to me. I failed the NPRE like three times because I just couldn't live in the gray area that is discretion. And so I most certainly understand that. And that's why my hat goes off to anyone who truly practices law, because I can definitely see that being something very hard to deal with. All right, all right. So, all right, I'm heading over to Val. See you soon, Rashad. Hi, Val. How are you?
Hey, Leandra, how are you?
I'm doing well. Happy hump day. Glad to see you.
Thank you, thank you. Thank you for having me.
Of course. Thank you for being here. Tell us a little bit about yourself.
Of course, my name is Val Charles Pierre. I'm the global head of eDiscovery for Goldman Sachs. I've been practicing eDiscovery in terms of a career path for about a decade and a half. And last week was actually my third year at Goldman, but feels like it was 30.
Congratulations. Listen, I think anything in e-discovery can grow you quicker than than it should.
Yeah, you see the gray beards. I feel like Obama in his first term.
Listen, that's a heavy burden to bear, but if anybody can do it, I know you can. All right. So what will I ask you, Val? Val, what's your favorite childhood memory?
Um, I, I wouldn't. My favorite childhood memory. I probably don't have one, but I will give you my favorite memory,
Okay.
and that is actually when Obama was first inaugurated. Me and my childhood friends, about four of us, went down to D.C. and we participated in all the series of events leading to his inauguration. And I remember we were walking and there was an older lady in a walker about like 93 years old, right? And just walking along with us. And, I stopped and said, "Hey, how are you? Are you okay with walking?" And she said, "Child, I've waited all my life to see this moment. This walk is nothing." So that's my favorite memory.
I love that. That does sound like a very amazing memory. Thank you for sharing. All right, I'm going to pull everyone up here really quickly for a quick icebreaker question, and then we'll jump into today's CLE. Okay.
Certainly.
All right, guys. And whoever wants to go first, feel free to go first. Hold on, let me move this. All right. Question of the day. If you could have one superpower, what would it be and why? So whoever wants to go for it.
I want more energy, especially as I get older. I want to be like a Superman who can, work around the clock at the same level after, that I would have had at 8 hours. I think that would be nice.
That does sound amazing.
I'd probably choose to slow down time. I mean, how useful could that be for a litigator? The ability to process things as everything else around me is moving at Mach speed. I can slow down and be in the moment. That'd be great.
Being in a room with attorneys and other legal professions, I think my superpower would be to convince others to see my point of view.
Ah, I love that.
I respectfully disagree with you about slowing down time. We don't need certain cases to take longer than they already do. But I think my superpower would be speak every language, just because it can be such a barrier to communication. And I think that being able to communicate to everyone across the world would be pretty awesome.
That would be cool. Speaking a whole bunch of different languages at once and not having to go to school for it. Sign me up immediately. All right, guys. So that was our warm up. That was our icebreakers. All right, I'm gonna send you guys all backstage again, and I'm gonna go over our objectives, and then we're gonna stop by and see Rashad, and he's gonna tell us about civil litigation. All right, give me 2 seconds. What's next? Boom. All right, so by the end of this course, you should be able to identify the following: the life cycle of a civil lawsuit, what eDiscovery is, the concept of eDiscovery, the key players in the industry are, and what are some career paths. All right, so really quickly before we get there, let me see. I don't know if I have anybody in the comments. All right, I don't know how this is set up, so I don't know who can comment or if you can comment, but if you can comment, um, who wants to win some free swag? I'm gonna be really upset if I can't get you guys free swag because there was a lot of time and effort that went into getting this swag for you guys. And when I initially got it, we got t-shirts, and I thought the t-shirts were gonna just have screens on them, but they're embroidered. They're some of the nicest, softest t-shirts I've ever seen. And they're not pink, they're crunch berry. I love fashion. So one thing about me, when you come and you win some swag, it's gonna look good. You're gonna be able to wear it out somewhere, and it's gonna last you some time. So, if you can, if you're in the comments, if you want to interact, for some free Beacon Hill swag, can you put in the comments what are the stages of the civil litigation cycle? And while you're doing that, while you're figuring out if you want to participate, and you're putting that in the comments, we're going to pull up on Rashad. Hi, Rashad again. How you doing?
Very well.
So I wanted to say I've been waiting to crack this joke since you agreed to do this. We're a long way from that pitch call, aren't we?
We are. We are.
Okay, so one warm up question, and then I'll let you jump into your presentation. But do you remember what grade you made in Civ Pro?
I want to say it was an I want to say it was either an A minus or a B plus. I don't know. I can't recall.
A minus or a B plus. That's amazing. Let me tell you, my Civ Pro teacher called me to her class after our first exam and asked me, was I serious about law school? If I wasn't, I got serious then. So I was far from an A plus or a B minus or anything of the sort. So again,
That's
I
all right.
always
They say C's get degrees.
hello, I
I
got
don't
it.
say that from experience, but they say that. They say that.
All right. So with that being said, I'm going to go ahead and I'm going to let you get into your presentation. Um, Tell us about civil litigation.
All right. Well, I see the presentation up there, and as I describe it, there are either 5 or 6 stages of litigation. The pre-litigation stage, the pleading stage, the discovery stage, and then pre-trial, trial, depending how you slice it, and then post-trial and appeals. And just take a step back. I think what is litigation or civil litigation? And as I have come to understand it, it's the way that we as a civilized country and people, redress wrongs, and resolve disputes. So your mileage may vary on whether or not your individual jurisdiction really resolves these disputes in a civil manner. But here in North Carolina, I like to think that we do things by the book here. What governs the process of civil litigation are the various rules of civil procedure, whether that be federal or state rules of civil procedure. So that's just a little set dressing. I'm going to quickly go through and describe some of these stages and some, hallmarks or keys, associated with each stage. And the pre-litigation stage, I mean, again, we're trying to resolve disputes between a plaintiff and a defendant, and what happens at the pre-litigation stage is different for both of those parties. But for the plaintiff side, I think some of the key markers is just the getting to know your client and the matter, what issue your client has, and doing the necessary research on things like statute of limitations and the various claims that you could bring, and making a sober decision about whether or not to bring a claim in the first place. Assuming you are going down the path of initiating a lawsuit, then I think one of the next stages is trying to engage in early dispute resolution, whether that be through a mediation or, just informal settlement negotiations. The cost of litigation is expensive and gets increasingly more so the further in the process you go. So I've been told by more senior attorneys that this pre-litigation stage is nothing to play with, and it should be taken with the utmost seriousness and preparation and exactness to what's going on, what's at play here, the different dynamics and different considerations. For the defendant, it might again involve getting to know your client, getting to know the issues, starting to do background research, and figuring out the facts, and also engaging in that settlement negotiation process. The pleading stage, lawsuit has been filed at this point, and again, you have 30 to 60 days typically to respond to a complaint if you're the defendant side, and if cross claims are brought or third-party complaints are brought, then the plaintiff has a similar amount of time to engage in the dispositive motion stage, motions to dismiss, and other 12B motions to clarify what the issues are going to be should the litigation proceed past the pleading stage. Then we have the discovery stage, and I think that's primarily what we're going to be focusing on today. And at this point, the lawsuit has continued past the pleading stage, and now we get into the nitty-gritty of figuring out what happened, who did what, and when and why. And all of this is necessary to gather facts that will help the plaintiff prove out his or her claims and help the defendant defend against those claims or prosecute cross claims or counterclaims. So this stage can be greatly assisted by eDiscovery tools and services, and some key tools in a litigator's, satchel are request for production of documents, interrogatories, request for answers, subpoenas if it's for non-parties, and depositions, which can help get critical statements for both the summary judgment stage and then trial if it gets there. I would like to say I'm often reminded that discovery is the most expensive stage of litigation outside of trial. And, sometimes the cost of things like depositions and discovery review can really push people to the negotiating table. So discovery is one of the more important stages of litigation. Then you have pre-trial and trial stage, and I think everybody has a pretty good idea just intuitively what this stage involves. This is the redressing of those claims on both sides, And I think, I mean, this is the Matlock. This is what you imagine it to be. And I would say, first and foremost, most disputes don't make it to this stage, and that's probably a good thing for all parties involved. Um, but some key hallmarks here are selecting the jury, um, clarifying what the tribal issues are, and developing jury instructions, and then the presenting of evidence that has been developed through the discovery stage. And once you make it through all that, you get through the post-trial stage, which is really about, if there are legal issues that came up during the trial stage, redressing those through various motions, and trying to appeal that to higher courts, addressing those issues there. And if all else fails, and you get to the judgment stage where you're everything has been resolved, appeals have failed, and now it's time to appeal to the lower court rather, for some sort of judgment against the parties that lost the dispute. Hope I probably skipped a ton. That was a crash course, certainly more crash than course. So if you have any other questions, Leandra?
Okay, so there was a crash course, and that's exactly what I was looking for. So, do you have a favorite phase of litigation? Like, I kind of, especially because we're going to be talking about the e-discovery or the discovery phase. Like, again, you remember I told you I genuinely struggled with civil litigation. So, to actually kind of be in the civil litigation and actually work in it. Well, two questions. Well, that question: do you have a favorite phase? And is actually practicing civil litigation anything like you studied in school, if that makes sense?
Well, I'll start with the second question first. Is it anything like what I studied? I mean, if you're talking about those doctrinal classes, the civil procedures, the torts and contracts, then no, not particularly, other than the process of reviewing cases, opinions, and applying those to a factual scenario. But if you're talking about some of my more favorite and the classes that I enjoyed more, like clinics, then yes, I mean, I think what I learned in clinics has been applicable to what I do on a day in, day out basis. The stakes are higher, of course. At least they feel higher, and I'm sure somebody could come up with a fairly good counter argument that the legal issues I was dealing with in clinic were just as monumental to the clients that I was serving through those clinics. But that would be my answer to that second question. My favorite stage, I gotta say, it's probably the discovery stage, the thinking through of discovery, propounding discovery, and responding to discovery, preparing for depositions, in particular. It's where I've cut my teeth the most in the last 3 years, and the various aspects that I enjoy. But I mean, one of my favorite is just getting to travel to different cities for depositions and whatnot. The process leading up to that can be stressful, but I do enjoy it.
Yeah, I love discovery as well. I actually love discovering. We'll talk about actually reviewing, and I know people have different feelings about document review, but when it comes to reviewing, I think that's my favorite part of discovery, because I don't know. I feel like you're really helping put the puzzle together, if that makes sense. All right, so I'm going to bring everybody up on stage and see what they have to add to the conversation, if they have anything to add to the conversation. So, all right, team, what you guys have to add? Nothing, something.
Well, that document review, in fact, has also evolved in a very interesting way. Now there's application of machine learning and AI and understanding communication. So from the olden days of going from document one to document last no longer applies.
Yeah, similar to that, right? And even with the inclusion of technology assisted review, right, and the evolution of that as well, has really driven down costs, right? Because in the beginning, for predictive coding, now machine learning or whatever, terminology you want to apply to that now, right? We have continuous active learning, whereas before we used to have the technology in which we had to continuously train the sample documents and iteration. So that's evolving as well. And now with the introduction of AI and all its possible applications too, it's just another way in the world of eDiscovery to help drive down costs. So that's just something that should alleviate outside counsel and us, the clients' concerns in terms of expenditure on eDiscovery spend.
So, question: we might go slightly, we might take a left turn, but I want to ask it. So, I see there's a big thing about like cutting down the cost, especially in when it comes to discovery, especially in e-discovery. But when it comes to AI, do you think the benefit of using AI to cut down costs is like, is it more beneficial or does it hurt the case, or could it possibly hurt the case more, if that makes sense?
Yeah, from go ahead.
Sorry, maybe steal your thunder. I think that, some of that assisted review on the front end does help save costs, because you can pull some of those key documents, figure out what the bones of the case are, and then help put that into your ESI protocols, especially when you're dealing with massive docs.
Yeah, and I think from the client's perspective, it's too early to tell in terms of the applications of AI. And we're taking like a conservative approach into leveraging that. So that has to be like a really good business case, and we're still like, no pun intended, trying to discover the various applications and how its efficacy could be towards those particular applications. So we're still dipping our toes a bit.
That makes sense. All right. Anyone have anything else on civil litigation? Any gems? Any Martin Luther King speeches you wanted to give about civil litigation? All right. No. All right. So with that being said, it's me and you, Jigna. I'll see the rest of you guys later. All right, Jigna, how are you?
I'm well. Thank you for having me today.
Thank you for being here with me. So really quickly, I'm going to do a couple just interview questions, and then I'm going to set up. So hold on really quickly before I forget. Marissa, I saw you. You won a t-shirt. Nobody else wants free t-shirts, I see. And that's not okay with me. I'm really sad about it, but participate, gosh darn it. That's what I want to say. So with that being said, Marissa, you got a t-shirt. And if you win anything while you're here today, just send me an email with your name and your address, and I will mail your free gift over to you. So Marissa, you have a t-shirt coming over. Also, you're about to get another opportunity. Whoever you want to, Marissa, if you want to win another shirt, you got a baby, you got a husband, he needs a shirt, you can enter again. So after I finish talking to Jigna, we're going to have another opportunity to win a shirt. So hopefully you guys join in this time. All right. So Jigna, I remember, and I think we talked about this before. So I want to call you an eDiscovery OG. I think a lot of people don't really know, especially it just depends on when you came into the eDiscovery industry. So I came in like right in the middle, but you've been here since the beginning. So I guess one of my questions would be, what's changed the most? And do you like the change, if at all?
Oh, absolutely. So, if Discovery used to be literally, the Redwell folder, you go to your file room, pick up a Redwell folder, and you make a copy, and you literally bait stamp those individual pages to deliver to the opposing side. And then during late 90s, that's when the tobacco litigation was happening, and they just had the warehouse full of pages. So that's when the whole electronic discovery came on board. And then really the industry evolves after the 2006 federal rules, revision, to incorporate ESI, especially Rule 26, and it included what really defined what ESI means, really defined their structure around it as far as production and really mainstreamed it. And so, I came right during that time, a little bit after that. And while things keeps changing, such as your data types, now we went from paper documents to email, and that was the Wild West. Now email is pretty common. Now we are going to collaborative data, such as your Teams chat or Viber. I think they use it overseas, and WeChats they have. So depending on what you have, also there is less of people calling or leaving a voice message, but there's a lot more Teams chat or video chats and recording. We are recording this particular panel today, so the capture of the varieties of types of data has changed, and that has presented challenges, but there has been track mark that has come up that it kind of guides the path forward.
Okay. I love that. Like, I love the evolution of eDiscovery. And I tell people all the time, I was like, I think we're still a baby in it. I sat in on I don't think it was a CLE, it was just a meeting. It might have been a CLE. And they were talking about Copilot and how a lot of companies are starting to, integrate Copilot. And they begin to talk about all that Copilot does. And I just thought, for somebody that's in discovery, Copilot is going to be somebody's gold nugget one day. And I just think that, the evolution of technology will force the evolution of e-discovery, if that makes sense.
All right. Any and all technology, pushes the path steps forward, right? It's the evolution of the technology, the way it's embedded. And Copilot or any of the similar artificial intelligence will continue doing that. But behind the scene, we'll still need somebody like Rashad or Val, who can understand the technology, who can understand the law, and really apply in an effective way.
And so you don't, and then I promise we're going to go to our presentation, but that's one of the main questions I've been seeing. Will AI or will, technology make like people like Rashad and yourself obsolete? And so do you think so? I don't think so. And I think based on what you're saying, it won't, because we'll still need somebody to basically manage and fact check that technology.
Right, absolutely. Fact checking, I rely on someone like Rashad or attorneys in general. These tell me this is interpreted correctly. But, for Val and I would say we have huge job security because we understand technology. We can translate technology to a non-technologist. And additional value added we have is that because we are humans, we can be creative. So it's not just a plug and play that, you apply, hammer to every situation. But if a wrench is required instead of a hammer, then we are able to decipher, the need and the application of any tool to that particular need.
That makes perfect sense. Thank you so much. All right. So really quickly, so we can go ahead and get into your presentation. Is there anyone here who can enlighten me on the concept of e-discovery? Put it in the comments. And while you're putting that in the comments, remember, let's here again. We're going to talk about this shirt again. I know you want one. It was a lot of time and effort. This is embroidered and it's really nice. It's free. All you have to do is answer a question. So feel free to put the answer to this question in the comments. And once Jigna finishes her presentation, I'll announce who won this answer. All right, Jigna, we're on you. Well, hold on. Well, we can skip that. We're on you.
No, thank you. So yes, EDRM was developed back in 2005, and there's this basic structure was developed back in 2005. It has received some evolution. And the way we read EDRM or electronic discovery reference model is going from left, which is your spinning wheel that you see, to all the way to the right, which is your presentation, which is anything pre-trial, trial prep related. And, as Rashad already said, a discovery is the most expensive part of any litigation, and it continues to be the most expensive part of litigation, even after you bring down the cost. The left side is really focused on your information governance, working with your clients to correctly store, not only correctly store the data, but also like the challenges categorizing of the data, especially because storage is so cheap. I don't ever delete anything. And that volume just keeps building on. So correctly identifying the document, any kind of data, and then correctly labeling it, and then preserving it based upon the retention policy or the any kind of laws that exist, for such as HIPAA, that you had to keep it for 7 years. Where I really come into factor as a consultant is identification, preservation, and collection. While we say we read left to right, it's really a circular process. So just because you go to a client and say, okay, this lawsuit is about a breach of contract, and I need to, I need all the data from, say, maybe salesperson, the engineer, the CEO, right? And those are the 3 people. That doesn't mean that that's the only time you go to the client. You can always continuously go back to the client based upon the evolution or how the case is evolving, very similar to if there's a countersuit, if there a lawsuit, a part of the suit settles, a part of the suits, is dismissed. So based upon the how the legal case evolves, your discovery needs will continue to evolve at the same time. So identification phase is identifying the correct data that attorneys will need to review and make sure it's preserved and it's collected in a forensically preserved manner, so we don't change the metadata. In eDiscovery, the world revolves around metadata. So think about metadata as in your email to be who wrote the email, who was sent from to CC, BCC. Was there a subject line? Was there any kind of attachments? Are you sending an email with the attached PDF, an Excel, or voice call, etc.? So all of those really, really matters that you not only collect it properly, because if you just copy and paste your email, you're going to change the date on that email. You may potentially change the recipient on that email. So we definitely don't want to just copy over documents or copy over emails. And then in between is where the green line is where the magic happens, where we are organizing the documents for the attorney so they can review various formats, various types of documents in a particular database or in some technology that you may have. So whether you're reviewing a PDF or an Excel or a voice call or a video call, it's all in one database. It's all reviewable by attorney in a very digestible way. And then you're applying analytics, various analytics that exist to help you, what we call, say, cull down the data or reduce the volume of the data for, time management, for relevancy, for cost savings, all of those reasons. And then production is where the eDiscovery world shines. Is we identify, say, here's the 10,000 documents, or here's the 5,000 documents. We need to date stamp. We need to correctly have a protective order in place. So there's a confidentiality stamping. And then you properly, in an encrypted way, deliver your data to the opposing side. And, it has happened that you want to keep an accurate record of what you have delivered to the other side, because I've actually worked on cases where other plaintiff side, we are a defense firm, so we are plaintiff side will come and say, hey, what about this document? And then all of a sudden attorneys are like, wait, we gave them those documents? So your organizational skills will be very, very important during this whole process. And then after the eDiscovery is complete, so once the productions are done, we kind of say that, informally say that, okay, the discovery aspect is completed, but you still have your case management or your pretrial continuation, so if the case doesn't settle and it's going forward, then are we able to organize our exhibits, building our chronologies, building your deposition databases, so that way you can engage, who has testified to what across the transcripts, across the depositions. And then eventually organizing everything you identified during your pretrial process, your discovery process, to present it to the jury or the judge in a very digestible, fungible way, so that way it's easily understood. Your point and your story is easily understood. There are tools out there that will help you create a lot of demonstratives, call outs, and you can, again, working with multiple formats of the exhibits to go from, let's say, a video to call out to a transcript, and be able to go through seamlessly using the technology is all within my purview, and it's within all entire EDRM purview.
So I feel like what you just said, it's like it takes a lot of time. So how much time in between actually like this process, the EDRM process, and actually going to trial? Like, do you gauge trial on discovery, or do you gauge discovery on the trial? Does that make sense?
Yeah, so historically, it used to be about 6 months that you have your facts discovery, and then you may have issue discovery. But now discovery process can go anywhere from 6 months to multiple years. There is just depends on the breadth of the data and the breadth of the issues.
Okay. That makes
These are various ways. I won't go through all of them, but very similar to what Val says. One of our expertise is to look at the data. If you have 100 documents, how can I get the attorneys maybe those top 10 documents that are relevant to this particular matter, right? So we use various options, various technology, various culling methodology to really help us narrow the scope. And it's really you're working with your technical nerd to help you be very thoughtful in how you are reducing your volume, because you don't want to miss anything, but then again you don't want to review everything. So it's a very fine balance.
all right. Any other gems you have for us before I bring the rest of the panel up to discuss this topic with you?
No, I think I'm happy to answer questions, but I'd love to hear what my panelists gems they have.
Let's see. All right, guys. All right. So I think Val, did you actually have some? Oh,
Yeah,
okay.
yeah. Just speaking on the client side, I will say those of us who are like heavily litigated, financial institutions, pharmaceuticals, we're bringing a lot in house in terms of the left side of the EDRM cycle, right? More of it is becoming in house, and again, no one knows our data better than us, right? So when engaging with outside counsel and external vendors, we can really give proactive analysis, especially towards legal strategy and collection, specifically having like such subtle nuances, for instance, as junk domain analysis, which I didn't see on that list, right? And really, the fact of the matter is, some of us that are heavily litigated, we have repeat offenders in terms of custodians, right? So we're collecting those custodians, several times, right? So we know, custodian A has a huge portion of Bloomberg blasts, right? That's just junk domains, right? So we've applied a strategy in order to fill that pre-exportation of the data, just to save cost, right? So I would say these are the things also that I would add in terms of a gem in the eDiscovery world.
Yeah, I definitely think just because I used to like I've been all over the eDiscovery industry, and I used to be like a project manager, and I used to have to put in tickets for culling, and I actually used to have to cull documents. And I mean, I'm sure they did it, but streamlining those junk domains sounds like a amazing way just to get a whole bunch of documents out and automatically drop those costs immediately. So
Yeah, based on the merits of the case, right? We could just look at emails and say, any communication that has recipients of 25 and over, just cast aside, and then also just add a listing of all the domains themselves, and then punting that back to outside counsel and having them review those domains. Let's just say CNN or MSN or any of that sort. They could say, pretty much strike all of that, right? And the counts associated with that is another calling mechanism as well.
all right, anyone have any more gems? And this is our check-in, our CLE check-in. This is the first neighborhood, just so you guys know. One, count one. All right, let me see. I think you might have had another one, Val. Let me scroll up. Did you want to talk about this one, Val?
Oh, which one is that?
Global MSAs for large corporations.
Yeah, and I think that'll be important to just segue into the vendors and clients section. So we'll just hold off for that.
Okay, perfect. All right, let me see what's next. All right, guys. With that being said, Marissa, 2 shirts for you. Tell me what sizes you need. Anybody else want a shirt? Participate. But if you don't, Marissa, she has family. She can wear all the shirts. Okay. All right. So with that being said, guys, we're gonna take some time for Val, and we'll see you again soon. All right, Val. My question for you, really quickly, is tell me about Built. What's Built?
Certainly. BUILT is an acronym for Blacks United in Legal and Technology. And simply, it's the brainchild of Robert Dawson, James Edwell, um, I'm forgetting, uh, Kep Kamoy Foster, and oh my God, uh,
Zelda.
Zelda. Thank you. Just having a brain fart here, and basically what we all the common thread amongst all those individuals and the community members of Built is that throughout our careers we are often like the singular person in the room or possibly even our practice, right? And just from a career perspective, just not having those who are similar to us in terms of providing guidance on how to matriculate through the profession itself, and just having that mentor mentee relationship where we would be comfortable in divulging like certain things about some of our obstacles. So Built was created, one, to create pipelines for individuals of Brown U and other minorities. Also to help with the networking aspect, the mentor-mentee relationship, and programming itself. So we're really about like 2 to 3 years, still in our infant stage. We just recently received our 501c3 status, and we're starting to develop tons of programming to accommodate folks of the African diaspora, and then also to really go back into the universities and law firms and tell them about this nuanced field called eDiscovery, right? Obviously, everyone jokes eDiscovery is incestuous in nature or a game of musical chairs because the industry is so small and everyone knows each other.
Definitely is a small world after all. The one thing I think with eDiscovery, either you love it or you hate it.
Did we lose? Oh,
Y'all,
okay.
y'all lost me. Oh my gosh. Sorry, guys. I was trying to. Well, I'm kicking you guys back off. Sorry. It's just me and Val. I was trying to make a joke, but I guess it wasn't funny, universe. But the one thing I want to say about eDiscovery is you have to literally be built for it. Like it's not for the faint of heart. It's very niche. It's very it's filled, and I say this in the most respectful way, it's filled with a group of nerds, but you really, really have to want to be here because it's definitely not made for the weak. So I definitely think we're built for this. And so my last question to you, Val, and then I'll let you get into your presentation, is what's one thing that you're proud of yourself for?
I'm just proud of the career I've been able to achieve, right? And then, I'll just segue straight into the presentation because I feel like my eDiscovery career lends to how I got here and how I look at the vendor-client relationship. In my eDiscovery career, I've had the unique opportunity to work from 3 different vantage points. One on the behalf of outside counsel as a project manager. The other is an eDiscovery vendor where, I ultimately climbed up the ranks to managing consultant and led pods. And that allowed me to be client facing and then also provided me with the technical expertise. And then finally, as a client, right? And as a client, I'm able to understand, legal strategy and compliance from the outside counsel lens. From the vendor lens, I have a deep understanding of the technology and process efficiencies. And as a client, I'm able to focus on aligning discovery solutions with the broader business objectives and risk management. And I feel like these diverse experiences allow me to navigate the e-discovery process in a comprehensive and strategic approach. That being said, as we move more and more towards the left side of the e-discovery cycle, as a financial institution, going back since the inception of e-discovery, clients tend to lean on outside counsel for vendor selection and then manage that engagement, right? Those of us who are heavily litigated decided to really work directly with the vendors in terms of pricing because at a certain time there was the introduction of fixed fee or flat fees, and that was something that really allowed the e-discovery vendors to engage directly with the clients. And then now the institution of master service level agreements as well, right? So for us as the client, having a preferred vendor panel of vendors we feel comfortable with, again, have to embark on our vendor risk assessment and technology risk assessments, making sure that our data is really protected, especially now in this day and age where you have a ton of breaches. So just sending it directly to outside counsel and not being familiar with all the guardrails and controls that they put in place, especially us where we just don't deal with a few external counsel firms. We have a myriad, right? So keeping up with the ever-changing landscape of our outside counsel, we know that the vendors, especially our preferred panel, is a known entity, right? And when we constantly reassess, their cybersecurity protocols annually, and then also with the master service level agreement, we come through an understanding in which, one, it's applicable from a global perspective, not just the U.S., but all the other various regions. And also because we're dealing in volume, we're able to really scale down the price further as opposed to dealing with the external counsel and their selection of the vendor in particular. Specifically for me, and I can't speak for others, my vendor relationship with my preferred panel is truly important to me. I don't regard, and I guess because I was once a vendor myself, and I know one of the monikers that we always preached was that we were a trusted advisor, not just those that just completed tasks, right? And I have that same level of expectation for my eDiscovery vendors as well, right? I truly have a relationship with each of my relationship managers of my various preferred panels. We have static teams that are Goldman team specific, especially again, because we're highly litigated, we're dealing with multiple matters at once. And then it's just a comfort for us to be able to call our project manager and know that that particular individual is going to be able to execute exactly what we need them to execute on. And then also, in the instance where we're kept off of communication with outside counsel, they know to loop us back in. They pretty much know our standard playbook, protocols, and processes, and really, are able to be my eyes if I'm not there in a particular room, and truly come up with solutions that are in the best interest of Goldman Sachs or the client, right? So that goes without saying in terms of our relationship with our preferred vendors and vendor pricing.
So a couple things, and then I want to talk through some things too, because you're really smart. So we might have some people who might not know exactly what you're talking about, and I want to talk through that. But so this is just like kind of a question, but what advice, because one of the things as I come into this world as like not a as a vendor, as like a real vendor in this industry, one, breaking into this industry is one of the hardest things I've probably ever done in my life, but I'm a fighter and you won't stop me. But what advice would you give someone who says, remember, we're built like, so what advice would you give to somebody who wants to maybe one day get a Goldman Sachs, but if not a Goldman Sachs or somebody, how should people approach you? How should they, how should they go about building relationships with you? Because you like you said, you were like, the people on my preferred vendor team, because what I learned is preferred vendor is the hot word, So how did you get people on your team? How did you get to know those people? Does that
Yeah.
make
Yeah, so I mean, Goldman themselves has like a protocol for vendor onboarding, and it is an arduous process, right? It could take up to a year and a half. So that's part of like the weed out process, and that's something that I don't have control over in terms of like onboarding new vendors, right? I can make that introduction, have conversations with prospective vendors, and based on the skill set and the technology stack that they're trying to sell essentially, if it's a good fit and if it's nuanced enough, I can make a good business case as to why this vendor needs to be onboarded. But even with that recommendation, that just only leads to the introduction of the onboarding process, right? If you fail the onboarding process, quite frankly, there's nothing I can do to help you any further in that instance. In terms of once onboarded, performance is key. To be honest with you, I will say like pretty much all the vendors, every vendor has pretty much the same solution, right? For the most part, and then you have just key nuances that one vendor does particularly well. You'll have vendor A is very good in mobile forensic collections and is a subject matter expert, right? And really knows how to ease client concerns in terms of pacifying them, in terms of their privacy and turning over their phone, right? You have another vendor B is really good on onboarding matters fairly quickly, right? And so you would leverage them maybe for internal investigations or things that we just need to hit the ground running on yesterday, right? And then you have vendor C who's really good at analytics. So like everyone has like their niche, right? And just knowing which vendor to select based on the conversations who you have with internal counsel and external counsel, and the strategy lends to who we select as a vendor ultimately.
Thank you. That makes perfect sense. All right. So really quickly, I'm going to run through these slides, and then I'm going to see. I think you have a couple more slides. I want to see if you want to talk on those, and then I'll invite our panel back up. All right. So what is a vendor? For people who don't know, in the context of eDiscovery, is a company that provides eDiscovery services to corporations and law firms. Okay, and so who is a client? A client is a corporation or a law firm that solicits a vendor to assist the company's e-discovery matters. So, what are some e-discovery services? So, remember what Jigna was talking about, where you had to go back, or we had to actually collect the evidence. We had to have people go and get that stuff. That's an e-discovery service. Somebody who actually goes and when there's a lawsuit and says, "Hey, listen, I need you to collect all the cell phones from here." All right. And so then you have this, so people sell that. That's a person, there's a company that sells that somewhere. There's a company that sells attorneys to review all of the information that was collected. That's me. If you need those attorneys, I'm here. But there's a company that does that. Then there's a project management company. My company does that as well. But you can go to a company and say, "Hey, I just need some project managers." You can get these things all together. And I think it might have been Val that was talking about this earlier, because you have fixed fee where people get this in a bulk, and then, or you can get a la carte. I just want one or the other thing. So think of yourself going to a nerdy grocery store and you say, "Hey, I need some people to pick up this. I need these type of people. I need these type of people. I'm going to put this in my grocery basket, and then I'm going to cash out because and I bought these things from a company." So that's what a vendor is, and that's what vendors sell. Okay. Val just talked about that. Did you want to talk about clients, or did you have any gems about clients or anything?
Yeah, just I mean, in terms of clients, right? If you're working from a vendor lens, um, just know that it's like a zero tolerance approach, right? Especially for bigger institutions, and because there are various vendors and various options, I think folks need to go in knowing that they are to provide white glove service. I think for us at Goldman Sachs, we absolutely required, and it's a default for us. So I will say that. And then also just be reasonable, right? In terms of how we understand that everyone needs to make money, right? But it also leads to making sure that you're not taking advantage of the clients, and the clients are becoming more and more aware of the e-discovery process and the life cycle and the intricacies of that. It would behoove you to just be really forthcoming on pricing and trying not to gouge.
That makes look, it all makes perfect sense to me. I'm doing way too many things at one time. All right. Do you have any OSC gems for us?
In terms of outside counsel, I think too from the client side and eDiscovery as a whole, traditionally you've had like heads of eDiscovery really have be attorneys, and that shift is starting to take place where heads of eDiscovery are becoming more technologists in nature. Just having that communication with, and then also outside counsel also loops in their heads of eDiscovery. So, on matter kicks off, just having everyone in the room at the same time to discuss this is probably the best approach, as opposed to like looping us in, after the fact.
Okay. And I'm going to invite everyone back up to see if they have anything to add on this topic. You guys are not a talkative bunch today.
I do think. Sorry, go ahead.
Andrea, you're first.
I want to at least say from a paralegal perspective, your paralegals can be your best friends in this entire process, in-house and outside counsel. When I'm working with a company as the outside counsel, when you pair me with the in-house paralegal, we are a team that is unstoppable. We know where all your documents are housed. We know what the good vendors are. I can make sure that I'm using your preferred vendor, or I can say why I had a really bad experience with that preferred vendor and they're not really good for your case. Stuff like that. So I think just overall, your paralegals are definitely a tool to be used.
Yeah, and just to piggyback on what Andrea says too, right? Especially dealing with a multitude of vendors, outside counsel, intern counsel has preferences, and during the the initial call, we have those discussions as well, and that factors in into vendor selection as well, right? But ultimately, I would like to say I have final say, but like I take into consideration a great working relationship, right? Especially if outside counsel says, hey, we've really had, a bad experience with vendor XYZ, we'd have discussions about that. And then, if we're aligned in whether or not to include vendor XYZ into the fold or exclude them, we'll make that determination as well. And then after like matter closeout as well, I like to reach out to internal counsel and external counsel and survey them on their performance as a key indicator for future vendor selection as well.
I will second that to Val, that having a postmortem, as they call it, after a project, it's very critical to understand the successes so they are repeatable, and understands the pain points so they are thought through and are covered hopefully for the next time, so you can have more different pain points.
Yeah. And for me, and I think most of my relationship managers as well, from the vendors will tell you that I'm extremely transparent. So if you're doing a piss poor job, you're going to hear it from me and why. And they tend to appreciate that. And I think that's something that's not practiced enough, I believe, from what they tell me, in terms of that level of transparency.
All right. Anyone else have anything else to add about vendors, outside counsel, eDiscovery, civil litigation? All right, guys, we are coming up to our last stop on this mental adventure that has been a CLE. Thank you so much. Oh, I forgot. So neighborhood again, this is the second neighborhood. So 2 times neighborhood. Got to get you those CLE credits. All right. So this time we're going to leave everybody up. And Andrea is going to lead a conversation about careers and career paths. Take it away.
Yeah. I need to be a little selfish for a second and talk about a little too much about myself. I have a bachelor's degree in psychology and lived in Pennsylvania. I went to the University of Pittsburgh. Worked in the mental health field, so very far away from legal, far from eDiscovery. I did that for several years. And then my spouse and I had moved from Pennsylvania. My husband got a great job offer, moved to North Carolina, and the laws between North Carolina and Pennsylvania are so different. So with the experience and level of career that I had in Pennsylvania, I could not get the same in North Carolina. And so it was start over and get all my credentials to be able to continue on the career path that I'd already chosen, or start something new. And I decided to start something new. And thankfully, it's been a wonderful decision. But I became a paralegal and really did a deep dive into discovery once I figured out litigation and got my feet wet very quickly. Started learning as much as I could as far as discovery goes, and how the eDiscovery process works, and got my master's degree from Wake Forest Law with concentration in business law and compliance. So I have a background in compliance as well, and investigations into documents and employment disputes and things like that, which really helped kind of round out my understanding of the eDiscovery realm. And then, meeting with vendors and service providers and the colleagues here on this panel, and being able to sit down and have discussions about, what everyone's seeing in this space. And so that interest for me has just kind of morphed over time. So I'm not just a paralegal, I'd like to say. I do a lot more. So there's a couple of different career paths that you can do if you don't want to be a lawyer, if you don't want to be a paralegal, if you don't really want to be in the courtroom, which I've heard. There's a lot of attorneys that don't want to be in a courtroom. They don't want to be drafting pleadings, but they love the discovery process. And so they do a lot of that. You can be a document reviewer with a vendor. So yeah, happy to have my colleagues jump in and talk about any careers that y'all know about, and I can keep talking about my colleagues that I work with.
And I would like to, before they or after they get into that, I want everyone to tell me how you got to where you are today, and I like how, what was it like, how, where did you start, and then how did you get to where you are? So anyone, go.
Sure. I guess I'm the talkative one, so I'll start. I actually started my career. I have a BS in kinesiology and pre-med, and I dual majored in management and information systems. So, after university, Penn State, Andrea, so we are. I know if you're from the Pittsburgh area. Um, I went to DePaul University, tried my hand at sports management, and quickly discovered that it wasn't for me. So I leveraged my background in information systems, and was actually a network analyst for Norton Rose, Fulbright. Prior to that, they were known as Fulbright and Jaworski, and quickly moved up the ranks, but then hit a glass ceiling, and then just had like project managers in litigation support come to me to help them solve technical solutions, and that's where I became fascinated with the industry, and then ultimately, petitioned to become a part of that department. And I recall like my first week of that department, we had Accelerate Recommend, so we were one of the first law firms to really try our hand at predictive coding, and I was working with a well-known leader in the industry with creating a white paper for predictive coding. And, we were going through our iterations. I had to ramp up so quickly. And within 2 weeks, I'm like, I'm not that smart. It was like super complicated for me. But then ultimately it clicked in. So I had my hand, be a junior project manager for a prestigious top AM 100 law firm, and then moved over to a consulting firm and really got my technical expertise there and did that. And, that allowed me to travel, see various parts of the world, really engage with like Fortune 100 companies, right? Because I was client facing. And then, ultimately decided to have a family, and that wasn't conducive to consulting life any longer. So I came into another bank, and where that was my first exposure to financial institutions and the eDiscovery world, and quickly found out that financial institutions weren't as mature in the eDiscovery model as the rest of the world. So I was able to make a lot of inroads there, and was really successful in really developing that department and that program and in that institution, which brought me to Goldman Sachs, which I'm replicating and expanding as well, which as we all know here, the eDiscovery world lends itself to lots of hours. But if you really like what you do, then it doesn't bother you as much.
Really quickly before anybody jumps in, and just like real quick, Val, you said you hit a glass ceiling. How did you handle dealing with that, hitting that glass ceiling?
Similar to eDiscovery, right? There's always more than one way to skin a cat, right? There's always a way that you can go about it in a different approach, and I just had to find that, and then take that avenue, and then let the chips fall where they may.
I'll take that. All right.
And I'll take it in between here. Same thing, as far as practicals go, my next option is become a lawyer. I don't necessarily want to do that. I love litigation, but being able to pull in some of the eDiscovery pieces to case management, project management, learning more about the, what to do with metadata and being the expert in that realm, and I can go and explain that to an attorney. That's the more you learn, I feel like, is how you kind of navigate that hitting the glass ceiling.
Yeah, definitely. All right. Who else wants to tell me how they got to where they are today?
I can go next. So I practiced civil litigation for Howry when I started for about 10 Well, I mean, I practiced for total for 10 years, not all of it with Howery, but and then Howery went under around 2011. It was one of the number one law firm in the world, in the United States. So it was really heartbreaking, but just it was right at the cusp of time where Relativity was coming online, which is one of the more popular industry eDiscovery tool right now. And then also there was a lot more conversation regarding technology assisted review. And for somebody who doesn't know what TAR stands for, it's kind of, thinking in the terms of Netflix or Spotify. You tell it like, oh, here's the 5 movies I like, 5 songs I like, and it will hopefully give you additional similar type or songs that you will like. So that concept was coming online, and there was a very similar fear as right now that, oh, is AI, is technology in general going to put us all out of business? And especially as an attorney. And so that's when I pivoted to the litigation support, eDiscovery world. And then I absolutely fell in love with technology. And I've been practicing eDiscovery technology. I've been practicing eDiscovery technology work for the past decade.
Thank you, Jigna.
Sorry, one last thing I will say is that if you have the JD, it used to be a liability to be in the eDiscovery world, but now it has become an asset. So if you're an attorney and are thinking about it, the transition is a lot more easier.
Okay. Thank you. And like I kind of want to harp on that because I think that like there's a lot of ways to be an attorney in the e-discovery industry. Like you can be a reviewer, you can be a project lead, you can be a review manager, you could be the outside counsel, you could be general counsel. There are so many different ways that you can be involved in e-discovery and not actually litigate or litigate. Rashad, can you tell us where you got to where you are?
Yeah, I think I have followed a more traditional, I guess, to the extent there is one, a more traditional path. Um, Before law school, studied, political science with aspirations to be an attorney. Um, Worked in North Carolina State government and politics for 3 years before ultimately going to law school. And then after my first summer, clerked with Moore and Van Allen, and loved my experience so much that I decided to come back. I loved it primarily because of the people, the more senior associates that took the time to really teach me the practice of law, and the partners who poured so much of themselves into my early career, and everything that I hoped the firm would be. It has been great opportunities to learn and grow my practice. So, yeah, like I said, I've been at Moore and Van Allen since graduating from law school for about 3 years.
Okay. All right. Thank you guys so much for sharing. Andrea, did you have anything else you wanted to add about careers and and e-discovery or careers in general?
Yeah, I think I do. There are, just for those who are trying to look to see what is out there, there are, a ton of legal tech conferences. ILTACon just happened. There's the ALA conferences that happen in most cities. Your local city probably has an eDiscovery chapter of some kind. Charlotte has a Women in eDiscovery chapter. There's just so many. The legal tech industry is so vast, but everyone is so nice, and it's a pretty tight knit community that like I'm happy to sit down and have coffee with someone and you want to just chat about it. And don't want to speak for everyone, but at least everyone that I have met has the same mentality about it. So even, there's a vendor that I could call up and say, hey, I have a question. I can't use your services right now, but can you connect me with someone who can help me? And that just seems to be the culture of the legal tech world. So if you're not sure what you want to do, or if you want to do more, I would start there.
Agreed. All right, guys. So I'm going to ask one last thing of you. Any final tips or takeaways? You got to give a piece of advice if you wanted someone to know something about you, if you wanted someone to know something about the legal industry. What would it be? So whoever wants to go first, and I promise you, I won't harass you for any more questions. I'm going to close this out after this.
I will say that I am on LinkedIn, so please connect with me if you like on LinkedIn. I do my best also to pave the path forward as somebody else has done for me to introduce me to this industry. So if I can be of any value added to your process, I love to be part of that journey. And then the second thing I will say is if you ever told yourself that, oh, technology, I can barely send an email or I can barely turn my computer on, don't worry about it. There is a learning curve. I am very much a person who believes that everybody can be taught and can learn the new skills. So if you are interested in exploring, please do so.
I guess harkening back to what I said at the beginning, something I've learned over the last 3 years is discretion. I think my advice to all the litigators, I would say junior litigators, but I think some of our more senior litigators need to remember this as well, which is form over function. I mean, as an attorney, as a young attorney, I've experienced or had exposure to so many forms and go-bys and routines and informal procedures. And I think it's important to keep the goals of any one action, whether that be discovery responses or discovery requests or pleadings, motions practice. It's important to interrogate the reasons behind those tools and those actions, and really question whether or not you're getting to the end goal in the most efficient way possible. If you can say it quicker and clearer, I think it's better to do that than just to rely on those sometimes stilted language and overly long prose. So in essence, I'm guessing I would suggest to really interrogate whether every aspect of a form or guidance is strictly speaking necessary. So
Thank you. Andrea, yeah.
Yeah, next. I would say probably this field requires a lot of adaptability. Being able to pivot and be okay with it, and you could have spent hours doing something that you now need to pivot based off of something that's just happened, whether that be a trial or even in the eDiscovery process. I have a colleague who says, "Hope for the best, but prepare for the worst," and I have taken that to heart every step of my career. I generally try to be overly prepared, and I think that should just be a general practice across all litigation, whether in-house or outside counsel, as well as for vendors and service providers. If you're prepared for the worst, then when it happens, hopefully the best outcome is what happens instead. So yeah, so adaptability, I think it's just probably one of the most important things.
Yeah, and to piggyback on Andrea is obviously just be able to pivot quickly and adaptability. And speaking of adaptability, AI is here. It's not going anywhere. I behoove everyone to start, ramping up on their understanding of AI technology and its implications. Currently, there is no true subject matter expert in AI. Everyone's on the same playing field. Please know that. So the best way to learn is through use. As you probably notice, as you go through all of your vendors, Amazon, Netflix, Spotify, Google, you'll see that the not so subtle integration of AI technology, right? And being in this industry, we really have to understand AI and its implications from a retention perspective and a discoverable perspective. So really start learning as much as you can about it. And then lastly, please don't use your personal phones for business. You know, you feel like, at this point, you feel like you shouldn't say that, but you'd be surprised.
Yeah, I definitely think that was a no-brainer, but everybody, like, again, everybody doesn't know better. So thanks for dropping that, Jim Val. Definitely appreciate that. And with that, let me see what the next slide is. And with that, I just want to say thank you. I want to say thank you to each of my panelists who put up with me and my rigmarole for the last couple of months, not knowing what I was doing or what I was getting you guys into. I genuinely and sincerely appreciate you. And I hope that you enjoyed this adventure. And then hopefully you like the playback. I hope you like how it looks when we run it back. But I genuinely appreciate each and every one of you. I did want to say thank you to my boss, John Tarbucks, Andy Wang, and my marketing team, Chris and Corey, for these amazing shirts. Let's talk about we have to make some noise for these shirts, okay? And don't worry, panel, you're getting shirts too. So crunch berries for you, okay? So thank you to everybody. With that being said, we have to sign out. Neighborhood. So that's your third neighborhood. In order to sign out for my CLE, I need you guys to send me an email with your name, bar number, and state you are seeking credit and the amount of times that you saw the word neighborhood during this presentation. And I'm going to email you a worksheet because in order to meet the qualifications for the New York City approved jurisdiction, you have to have some type of paperwork. And so that's your golden ticket. They probably won't ever ask for it, but just in case they do, I want you to have it. All right, team. Do you guys have anything else? If not, well, I don't know. Anybody in the chat? Do you have? Dawson said he agrees with the importance of transparency. Val, did you want to speak on that? And is there any questions from the audience while we're here?
Yeah. No, in terms of transparency, I think, that it speaks for itself, right? Having honest communication with your vendors allows them the ability to do better, right? Just even with my career or during the review process, I always, speak to my reviews. I really don't care to know what I've done right. I just want to know what I need to improve upon, because that's what makes me better. So I have that same level of expectation from my vendors.
Thank you, Marissa. Thank you to everyone who joined us today. Thank you to everyone for participating. And I'll give you a couple minutes of your time back. You guys have a great day, and hopefully we can do this again soon. Bye, guys.